Maybe before she, my lord, I may be permitted, my lord, today for my lord moving on this state, my lord, motion matter, my lord.
What is this matter about?
A little bit urgency in this bill, my lord.
Anticipatory.
Yes.
Get released tomorrow. You are here only.
I'm no, my lord.
Counsel from tomorrow.
My lord, I'm off. I was station later, my lord.
What?
A little bit urgency matter because day after tomorrow on I was supposed to appear, my lord. It's regarding anticipatory bail. Last time, Lordship may recall, my lord, one of my senior friend moved. One of the petitioner number 2 was, my lord, because of some technical that matter could not be part of.
Afternoon.
Yes, my lord. Oblige, my lord.
Your Honor, I'd like to mention item number 28. The leading counsel, Mr. K. Tamba, is out of station due to medical emergency. Due to medical emergency, he's out of station.
Therefore,
for the respondent.
respondent.
Yes.
Have you informed the petitioner?
Yes, Your Honor. We have taken consent from the opposite party as well.
Okay. Miss
D. Rita.
B.
D. Rita.
Garnet counsel. So, appearing on behalf of. Who is the conducting counsel?
Mr. K. Tamba.
K. Tama. With the consent of the land counsel for the other side. Praise for. When do you want?
2 weeks would be fine. Your Honor.
2 weeks.
Yes.
Praise for listing this matter after 2 weeks. The prayer is allowed. List this matter after 2 weeks.
Yeah, Lordship. I beg to mention item number 6, Lordship, on behalf of Mr. B.K. Misra. He could not appear due to personal difficulties, Lordship. I have taken consent of the other side.
Okay.
Dismissal.
Mr.
B. Padung.
B.
Padung.
Father, submits that the conducting counsel, Mr. B.K. Misra, has some personal difficulties today. And as such, he has obtained consent from the other side for listing this matter after
break.
Break. The entering puja vacation. So the prayer is allowed. List this matter after entering puja vacation. Okay.
Obliged.
Lordship, I would like to mention item number 4. I am from the respondent side. I have taken consent with the petitioner. So, you know, I'm not ready for the hearing. So matter may be fixed after vacation.
After vacation. You are Mr.
P. Tatam.
Land counsel for the respondent with the consent of the land counsel for the petitioner. Praise for listing this matter
after vacation.
After 2 weeks. The prayer is allowed. List this matter after 2 weeks. Okay.
Deeply ours.
My lord, may I mention item number 5?
Item 5.
Yes.
You are for?
Respondent. My leading counsel out of station.
Out of station?
Yes.
So have you informed the counsel for the petitioner? You are for the petitioner. You have no objection. Okay. Mr.
P. Padu.
P. Padu. Appearing on behalf of Mr. Ramji, who is the leading counsel? Ramji Kamsap. Sorry, Raksap.
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 Yes.
Praise for listing this matter after 2 weeks. 2 weeks. To which Mr. You are Mr. Land counsel appearing on behalf of the petitioner has no objection. Accordingly, the prayer is allowed. List this matter after 2 weeks. Stop. Para. The interim order passed earlier shall continue to the next stage. Okay.
My lord, I on the behalf of conducting counsel at attack would like to mention item number 8. And said conducting council is out of session due to domestic problem. Therefore, my lord, matter may be listed after eviction.
For the petitioner.
Yes, my lord.
Okay. You are Mr.
Tigami.
No, no. This is fixed yesterday only, I think. Hearing was completed yesterday in this case. And today he only was to show some authority if there is any. Let us see. Let us see. Wait for some time.
Pardon, my lord.
It was on his request only. It was fixed today. He had already forwarded his argument yesterday. Only the order was to be passed today. Isn't it?
Yes, yes, my lord. When the conducting council come, he will submit the.
When do you want?
My lord, after evictions.
Mr.
Tigami.
Land advocate submits that the conducting council, Mr. Pada, is out of station and prays for listing this matter after whose application. Start. The prayer is allowed. List this matter after after ensuing whose application. Okay.
Your Honor, I'd like to mention item number 30.
Item
Number 30.
13.
No, 30.
30.
The leading counsel for the respondent is out of station as he is going through medical treatment.
Your
So, respondent.
respondent, have you informed the counsel for the petition? Okay, no objection. Okay, you are Miss
Radhayakam.
Aryakam. Okay. Submits that the leading counsel, Mr. S. Koran, is out of station and prays for adjournment of the case for
3 weeks.
3 weeks, to which Mr. Embat, Land Counsel for the appellant, has no objection. So the player is allowed. List this matter after 3 weeks. Okay.
Much obliged.
May I please, Your Lordship, I beg to mention item number 24. Your Lordship, I've been informed that my senior, Mr. R. Swikia, is the new engaged counsel in this case. However, he is out of station on personal difficulties. So I humbly pray this matter may be listed after puja prayer.
For the appellant.
Yes, Your Lordship, appellant, Your Lordship.
Okay. You are Mr.
I, Bami.
Land Counsel. Mr. I, Counsel.
24, 25, 26,
Submits,
27.
Mr. R. Saikia has been recently engaged in this case to appear on behalf of the petitioner. However, he is out of station, hence pray for adjournment and to be listed after
Puja break.
puja break. Stop. The prayer not objected. Stop. Accordingly, the prayer is allowed. List this matter after puja vacation. Okay. 24,
24 to 27 units.
24 and 27.
24, 25, 26, 20. This is
Up to 27.
Yes, connected letter.
Okay.
highly honorable.
May I please, my lord?
Yes.
My lord, I beg to mention item number 18, my lord.
18.
Yes, my lord.
Yes.
Matter may be adjourned today, my lord.
Why?
Lordship, this is civil revision petition record has already been received.
Okay.
So, Lordship, this matter may be listed on 23 in admission year. I am for the respondent.
Okay.
Admission hearing on 23. Records already received.
Okay. You are for?
I am for respondent.
No. Are you,
I am for the petitioner, my lord.
so when do you want this to be?
23rd.
23rd.
Yes.
October.
Okay.
Okay, on the joint prayer made by both the land council for the parties, list this matter on 23/10/2024.
My lord, interim is there, my lord. Let me continue.
In the meantime, the interim orders will continue
In admission hearing, Lord.
till the next day. Okay. Then on the prayer, on 23/10/2024 for admission hearing.
Yes.
Okay,
Obliged.
yes,
Mention item number 22.
22.
Yes, your lordship. I'm for the petitioner, your lordship. The conducting council is out of station, performing some rituals. It may be listed after vacation, your lordship.
You are Mr.
J. Taipodia.
J.
J. Taipodia.
Taipodia submit that the leading counsel for the petitioner is out of station and pray for adjournment. Prayer allowed, list this matter after
Vacation.
2 weeks. Okay.
Lordship, interim is there.
Interim is also there. Stop the until then, sorry, the interim order passed earlier, so continue till the next stage. Okay.
Much.
Yes.
May I, my lord?
Yes.
My lord, I'd love to apprise that earlier, my lord, in terms of section 37 of Indian Act, all the offences under this act was not bailable. But as per the order of this coordinate bench of this court passed by R.K. Pukhan in criminal petition number 814, section 21A and 27 has been made bailable. So we have filed a bail application on 3 occasions in lower courts, but it has been rejected. So my simple prayer would be, my lord, my petition may be rejected on maintainability with a simple observation that I may approach the lower court under appropriate provisions of law. My application has been rejected twice, though it is bailable.
It's bailable.
Yes,
Then why you have filed here?
because my application has been rejected twice, my lord, by one JMFC and by NDPS special court twice. Admittedly, my lord, this issue has not been raised here. Therefore, my simple prayer is, my lord, for rejection of my application on maintainability with a simple observation that I may approach the lower court under.
Is it bailable?
No, my lord, no, not bailable. But in my lord, is my lord, his prayer is that he's seeking for withdrawal with the liberty to approach before the trial court. Not with the exactly, my appropriate
No,
lord, application.
no, so his prayer is something different, more than that. It appears.
Otherwise, in this case, my lord,
Hmm.
so far the custody is concerned is more than 75 days. And in a small quantity, my lord, the statutory period is 60 days.
50 days only.
So therefore, my lord, even,
Okay.
but to ascertain that fact, my lord, I have to see whether a charge sheet has been filed or not. If a charge sheet has been filed, my lord,
They can make an application before the appropriate court having jurisdiction. So. Okay.
My lord, I have.
You had no idea
by
that
this
the
court.
60 days crossed.
My lord,
You had no idea at the time of filing this bail application that 60 days crossed statutory period. Also
I have
over.
an idea.
Okay, then have you made application under that? Month?
Dear, my lord.
Hmm?
Not there.
There
my
or
lord.
not there, not yet.
Actually, in the lower court, the different advocate was dealing this case. When I was here, I appraised them, but we were of the opinion that we need
So
some
if you
direction
want
from this court.
withdraw, that can be
With the liberty to file.
with the liberty to file only. No other observation. Okay. Mr. Land counsel for the petitioner wants to withdraw this bail application with liberty to file the bail file afresh before the appropriate court. Mr. Seri, Land he has no objection. Stop. In view of this bail application stands rejected. Sorry, dismissed on being withdrawn with liberty as prayed for. Okay. No one appears. No one appears on behalf of the petition on call. This matter. Oh, anyone? Anyone? After puja petition then, okay.
May I please, Your Lordship?
Yes,
My lord, here I'm filing application under 482 for quashing of sessions case number.
it's a
eight-
sessions case.
Yes, because the charges have been framed under 307. But there has been a settlement between the parties.
Trial begun.
Trial has started,
Okay, evidence recorded,
not yet,
not yet.
not yet. Prosecution evidence is to start. Tomorrow is the date fixed for prosecution evidence. My submission is, Lordship, as your Lordship may know, in various Supreme Court has passed in various cases. Although the charges here is one of the charges is 307. My submission here is that even if the charges have been framed and even if the charge sheet contains 307, the facts itself do not disclose that. So court has also to see that just because 307 is mentioned, it does not mean that the ingredients, if not satisfied, then the court cannot quash.
Medical report also.
Yes,
Whether
yes, medical report also have enclosed. Medical report is, Lordship, at page,
the allegation straight away
yes,
attempt.
yes. What happened is, Lordship, this petitioner 1 and petitioner 5, they are the co-wives of petitioner number 4. So there was a dispute amongst them, and the petitioner number 1 is the first wife, petitioner number 5 is the second wife, and there was since he did not want him to marry the petitioner number 5. She had a quarrel with them and she caught them red-handed in bed. So there was a sudden provocation, and that is how it has been, the FIR has been lodged.
Grievous,
Lordship,
the injury seems grievous.
Lordship,
nature.
just because the injuries have been mentioned grievous,
Use the sharp weapon.
yes, the
Will it
sharp,
be possible, because even if the informant cooperate also, but then how do you change?
Lordship,
How are you going to
Lordship,
change the
in
victim?
in this my submission is, Lordship.
Hmm,
In law, in the criminal law,
hmm.
there is nothing called as grievous injury. What has been defined under the IPC is grievous hurt. Now, if it doesn't fall under the category of grievous hurt, then just because it is mentioned grievous injury would not mean anything, Lordship. Now, Lordship, another thing is, Lordship, the situation in which the the offense is alleged to.
Grievous in nature.
Yes, that is, Lordship. But that by itself would not amount to say that it is an offense punishable under 307, Lordship.
You have annexed the photographs also.
Yes, Lordship.
Looks
I have
like
annexed the
serious.
whole charge sheet so as to be very transparent.
Looks like very serious.
Yes.
But
Now,
then-
Lordship, the injuries in respect the any of assailant can be gathered from the body parts that he is attacked also, attacked also. It has to be the vital parts.
that
That can be seen from the injury report itself. So, Lordship, since the matter has been settled amongst us, there is no chance of.
Difficulty. So what do you say?
The law in this quashing petition
Hmm.
on the basis of a compromise is no more res integra, my lord. They are clearness of judgment.
Yeah.
Only those cases which are predominantly of civil nature or arising out of matrimonial dispute. My lord, this is a case of 307. I understand, my lord, merely quoting or incorporation of section 307 will not ramifies here. There has to be a material.
Yeah.
Now, if we peruse their petition, my lord, it discloses the fact that the charges has been framed under 307. Meaning thereby they are materials, my lord.
After finding.
Yes, my lord.
Ramification case
Yes,
against
ma'am.
accused.
Therefore, at this stage, my lord,
What do we do?
only call
We
for
should-
the LCR, my lord.
Hmm?
The scan copy of the LCR.
Then no stay at that stage at this moment.
Lordship, tomorrow is the prosecution evidence.
Let-
Lordship, may I,
From there also, because the, you
Yes.
start with the evidence
yes,
of the informant,
yes.
and then informant.
Lordship,
you-
I'm,
Informant is only,
yes,
take care.
Lordship.
Huh?
No, Lordship, just one point, Lordship. What my learned friend has said, I'm agreeing.
Right.
But this court under 482, the hands of this court are not tied just because charges have been framed or
Then
just
we
because,
give
yes.
some Notice.
Yes,
Give
Lordship,
notice. But then
Lordship.
stay at this
Yes.
case, under the circumstances of the case.
Yes,
Still
in that
difficult.
case, Lordship, a short date may be
That's why I'm
fixed.
giving an opportunity.
Yes,
Hardness and land council for petition. Okay. 973, praying for washing of the washing of charge sheet number 1924, 19/2024. Under section 120B of 4(5). None arising out of SEPA PS case number 41, 2024.
so Lordship, sessions case number 8 of 24.
Okay. To the case number 08/2024. Which,
Bombila.
where it is mentioned? In the session case, it should be not mentioned. Have you annexed the order also?
No, Lordship, I'm not
How
an
the
ex order.
Bombila, like
But it is at Bombila,
Bombila
Lordship.
session, it's not mentioned. Session case number 08/2024, pending before the session judge. All for the scan copy of the trial court issue notice. So that this is a joint petition.
Yes,
Okay.
all the
Then
all the
it is just
petitioners are
filed by
accused and victims.
in beginning. Since Mr. Lanapiti has accepted notice. May appear and accepted notice. No, for one notice need be issued. However, you have received the copy of.
Yes.
Okay, not. Okay. So this just matter. After. So that.
Lordship, state may be given.
Okay, when?
22 of October.
Yes, 22nd October.
22nd October. In prayer shall be considered.
Obliged.
Yes. Yes.
Yes, my lord. Last occasion, this honorable court has called the Elshire report from the lower court. I don't know whether the report is
Ability to charge it.
yeah, it's already calculated, my lord.
Charge
PW,
framed
yes, PW stays, witness stays,
witness.
yes.
How
So,
many witnesses? have
it's
been
already
now?
4 or 5 witnesses already.
What
So, my lord, here,
is the name of the informant?
informant, this is, top, Tarun top complaint. This is the, merely small issues only, breach of trust, when, what are the relative only, as a good pet,
Just
he
a
has
minute,
entered over the bike,
Informant is
Uh,
TC talk.
Tarun Kamdir top.
Okay, so you said that thereafter you enter into settlement.
Not to the, this is the section, which is inserted by police, eye of the case, that is not at all wrong. Only
So charge frame under what section?
the old, most of the section was already framed.
No, charge frame under
Section, section, 406, 468, 465, 471.
465, 471.
Yes. Here,
34 is also there.
34 is not there.
Hmm?
34, yeah, 34 is there. Here, my lord, here exactly cases like that.
The informant must have stated in deposed.
Yes.
Yeah.
So there's an objection before the Honorable Trial Court that section 468, 465, 471 is, it is not at all attractive to me. Because I didn't,
Attracted then.
means I'm accused on this 468, 465, 471, it is not attractive because I didn't make any forgery against this complainant, informant. So 406 breach of trust may be there. So even after making objection, they have preliminary charge, honorable court has. So I'm coming to honorable court today is for quashing of the setting aside this case. Party has already made agreement. There is no dispute at all. So they have settled. This moreover, this case is old case, very old case, 2007 case. Only mere issue only the bike, only small bike, old bike. The issue that only. Breach of trust. Yes, of course there was breach of trust here.
You should have told the owner, this is old bike I'm going to take and not going to return.
No, yeah, that's why, my lord. We have after evening we try to withdraw the supposed case at before case. They said meanwhile the case is already go ahead.
Yeah, sold the bike also.
Now this is actually this complaint should lodge by the other person, the second person. They should lodge against complaint against me because they said I have made a forgery against RC. So they should. If there is, but this person I have not even we have not any agreement or anything. Only breach of trust.
It can see lordship.
He did not-
Lordship, yes, lordship. Actually, this FIR lordship is from the lordship complainant lordship. May lordship go to the lordship.
and made him to sign. SI and ask money.
Lordship, that is his deposition. That's why
That is the
lordship.
position. That is
Yes,
why I
lordship.
say.
And lordship, but the 161 lordship, his statement is
And
otherwise
you
lordship.
see,
Yeah, lordship.
this TC Toh is the informant,
Lordship. But his
owner of the bike.
lordship, that's why lordship 161 is informant lordship. In the under 161 statement, the informant has revealed everything lordship as a fake lordship. But again, lordship, in the deposition lordship, his statement is changed lordship, has changed. Lordship can go to the deposition of the PW1 with the complainant. It is record lordship, it in the record.
There is a serious allegation against the police.
That's why lordship may.
We try to withdraw.
And then the informant himself has requested for this
withdraw.
release.
That's why lordship statement is like that only. So
Informant
lordship,
has requested to withdraw the.
whether lordship has either lordship, it can be proceeding, lordship can be go on, otherwise it can be quash lordship, because as the
Yes, sir.
statement lordship is contradiction of the statement of 161.
So there is, how many witnesses remains to be examined?
Lordship, I think as per the record, only one is examined lordship as per now. And someone was issued lordship,
No,
other rest of the
No,
accused.
there is other. The position recording witness number 3 is also there. This is when is the last, when last you appeared before the trial court? It's in the verge of completion of trial. If there is nothing against you, you should allow the court to conclude and then get an acquittal order. Hmm? Now at this stage, when entire evidence has already been recorded, you entered into this agreement and want the case to pass. How do we appreciate all this evidence? Hmm? Can we? Because almost completed.
That's why, finally, Your Honor, my lord, here actually in what court, we have a trial court, we have made an objection regarding this all the section, only except the one section 406, that is the compoundable. So we, while making after agreement, we approach before the trial court, the section, this section, all the section, it is not at all attract to me. So maybe compound, but they said no.
I also give already, I also have been examined. Now you want, because the trial almost completed, you want judgment to be passed by this court.
By this honorable court. Yes.
Why?
Because I'm apprehensive that when I have raised this section to this is not draw direct to me. It can be not inserted. It can be deleted. It can be this a section which is not at all direct to me. But they are not listening the honorable court trial court. So I have only option here the honorable this honorable court.
There's nothing.
Yes.
You get acquittal order from trial court, it's better. How do we appreciate and says that there is nothing and he is acquitted? How do we pass that order?
That's why I'm apprehensive that when I raised objection before that during the time of CC.
There is nothing against you. I also did not say anything much.
Maybe pass an order from this honorable courts.
See, the informant also not implicated. Rather, he is implicating the police.
That's why
Implicated the police.
I said the complaint. This we have not made any agreement.
No, this is misuse of 482. Filing anytime.
Even we try to the this informant say that
Under the circumstances, how do if there is is there any stay here in this case? Stay of proceeding.
there's no stay otherwise.
So if there is no stay since 2023, then the trial court could have been disposed of.
No, my lord, I have informed to trial court that the proceeding is the quashing application I have filed before the honorable court. Even I've informed to the JMFC trial court.
No, there is no stay order. What prevents the trial court to proceed with the case?
Yes, sir, Lordship.
If there is no stay,
Lordship. He is submitting that, Lordship. He has applied that court that under 42 this matter is going on before the High Court.
So then
But filing doesn't mean the stay. It's not
Yes, sir.
stay.
The last updated was May, Lordship, May 2024.
That is what I'm saying.
Okay.
What prevents the judicial JMFC to pass order to proceed with the trial of the case?
Yes, sir. Although there was no interim also.
There is no interim.
No,
That is
no
why.
interim. Only I have been made informed before the trial court that this quashing application I have moved before the honorable court. It's pending. So up to you whether the case may be further proceeding.
No, this is total misuse of section 482. And then submit before the trial court that since I have filed application under 482, not to proceed with.
No, I didn't say that not to.
Then why to inform unless there is a stay? And then you did not appear thereafter. So then what to do? What is your submission?
Lordship, my submission as per this, all the records, Lordship, there, Lordship, either it may be go through the Lordship, the proceeding will carry it out, Lordship. Otherwise, Lordship is think that it can be Lordship, the conviction is
What is
vital.
ground
then
for
it
your
may-
filing before this court? Because it was proceeding properly. It was not against you. What is the ground for coming before this court? Why?
Actually, I was apprehensive that because during time of even I said that the CC, I raise objection regarding this section. And moreover,
See, if there is a prima facie case against the accused, the court definitely will frame charge against the accused. And it is you who is to disprove. During the trial by way of cross-examination.
and we have this both the parties, they are related also. They said, no, this matter should not be pursued further. So it can be settled amicably. Within us, we have made a deed of agreement to settle, made an agreement. So, and this accused person is government employee.
Accused person is
He is government employee.
government employee.
Yeah. So we are apprehension that tomorrow if something will be come out, positive or negative.
This petition is filed by joint petition.
Yeah, joint petition.
After recording of all this evidence, you enter into agreement. And yet you say that he is a relative. Okay. Mr. Rigya, Land Council for a petitioner. I've also heard Ms. Lakshmi, Land Edison people. So rest order I'll pass. Okay. Let's look at the item. 7, huh? 7, this will be displayed of, huh? Yes.
No, please, my lord.
Yes.
My lord, I am agree with the impugn dismissal order dated 3/9/2024, my lord, which my lord will find at page number 19, my lord, the last page, my lord. 19, 19.
Okay, so impugn order is it?
Page 19, my lord.
This is appeal.
My lord,
Yes, page 19.
Yes, my lord. When this order, my lord, the complaint which I had filed, my lord, was dismissed on non-prosecution.
Complaint is absent
Yes, ma'am.
without the steps. Accused also absent.
Yes, ma'am. In fact, here, my lord, the accused has never appeared before the court, ma'am. I've had a complaint under 138 NI Act, my lord, for non-payment of
Just
75 lakhs.
execution report of NBW issued against accused person not returned.
Yes, my lord.
So that is why probably the accused remain absent.
Accused has never, as many as they
Never
were,
appeared.
never appeared.
But then the complaint,
Because it is an NI case, my lord.
yes,
And it
yes,
pertains
that is-
to an amount of 75 lakhs, my lord. So I've had a complaint, my lord, that summons were issued, he never appeared, warrants were issued, my lord, on various occasions, my lord.
Okay, so
My lord, the complaint case was fixed
so
on.
accused never appeared.
Never appeared, my lord.
Okay, so on that day, but then this, as per the record, as per the impugned.
I remain absent on 3 occasions, my lord.
Yes, you also remain.
Yes, my lord.
So that is why,
However, my lord, therefore, my lord, I'll try to substantiate, my lord, on that particular day when the case was fixed, my lord, on 3rd, my lord,
Okay,
at page number 15, my lord, is the cost list of the learned code below, my lord.
yes,
At item number 13 is my 13,
item
13, at page number
13.
13. Serial number 13 is my
Yes.
item.
Complaint case.
Yes, my lord.
Okay.
Now, on that same day, my lord,
Hmm.
if my lord turns to page 16, my lord.
This was on 3rd
Yes, my lord.
September.
3rd September.
Okay.
16, my lord, may kindly see, turn to page 17, my lord.
Yes.
Item 12, 13, and the next page, my lord, 26 and 27, my lord.
Hmm.
The counsel for the appellant, my lord, he had some cases in the Honorable Guwahati High Court, my lord. So, since it was listed at item number 13, my lord, the counsel for the complainant, my lord, he was in the High Court, my lord.
Okay, so
In the
item 12 and 13.
12, 13, 26 and 27.
26 and 27. So no one to represent you also to
Yes, my lord.
appear before the trial court.
Therefore, my lord, on that particular day, my lord, I was in.
So 26 and 27.
Yes, my lord.
Your name appeared.
Yes, my
Okay,
lord.
so
27, my lord. It
27,
is
yes,
weak, my
yes.
lord.
Okay.
So on that particular day, in fact, my lord, in good faith, my lord, I was waiting in the Guwahati High Court for my item to come, my lord. And at around 11:30, when I went back to the learned court below, I was already apprised that by the pesca that the matter has been dismissed on non-prosecution, my lord. It was not deliberate, my lord.
All this listed for first time.
Yes, my lord. First.
Okay, so you can issue notice.
Yes, my lord. My lord may
Okay, otherwise-
petition and my lord may issue notice.
No. Mr. Opar, counsel for the petitioner. This is an appeal under section 378 within bracket 4 of the Code of Criminal Procedure. This was dismissed on, I think,
3924.
so probably you may have to mention the BNS. SSC corresponding section, because this is after July.
Yes, but then since yes.
3/9/2024. the impugn order was passed on 3/9 only. Okay. Especially the impugn order details. 3/9/2024 passed by the Learned Chief Judicial Magistrate UPR, by which the complaint case number CR, complaint case that is CR number 33/22 under section 138 of the NIA Act 1881 has been dismissed for non-prosecution staff. The appeal is admitted. Called for, the record need to be called for.
Yes, my lord.
Okay, call for the scan, call for the trial court record. Staff, issue notice returnable by 4 weeks.
My
3
lord.
weeks or 4 weeks.
4 weeks, ma'am.
Okay, start. The petitioner shall take steps upon the respondent by a registered post with AD within a week from today. Start. List this matter after 4 weeks.
The matter may be admitted, my lord. It may be admitted, ma'am.
Admitted.
Oh, my lord. Deeply obliged.
Okay.
My lord,
Yes.
I'm appearing for the first time, my lord. This morning I had filed my Bakalat Nama, my lord. I'm appearing for the first time, my lord.
First time.
Yes, my lord. I had filed my Bakalat Nama this morning.
Before the respondent.
Yes, my lord.
Lordship, there is 3 respondents. 3 respondents.
3 respondents.
Yes.
You are representing,
Yes, 3 of them.
Okay, 3, all the respondents. Okay. Mr.
Elba,
Lana counsel for the petition. Stop. Mr.
Adam.
Lana counsel could appear on behalf of the all the respondents. You have already filed Wakalatnama?
Yes.
Okay, by filing Wakalatnama. Stop. This is, what is this matter about?
civil division, Lordship.
Okay. Whether the record was called for. Okay. Read some put appearance by filing Wakalatnama and praise for some time to go through. You have received the copy?
Yes, ma'am.
Okay. And go through the petition stuff. The prayer is allowed. List this matter after
4
weeks, Lordship.
4 weeks.
My lord, scan copy of the LCR may be called, ma'am. Scan copy of the LCR may be called, ma'am.
LCR not called for earlier.
No.
Okay, in the okay, in the above, then the trial court record would be necessary for adjudication. So accordingly, call for the record. Scan copy of the PCR. Trial court record.
Well, Lordship, there is interim, Lordship.
There is
Interim, Lordship.
the
That may be
interim
continued.
passed earlier shall continue till the next date. Yes.
Okay.
May I appeal, Lordship?
Yes.
Lordship, it's an application under section 483 of BNSS. They have allegations against me is that which is in FIR, lordship will begin from page number 18 onwards.
Yes,
Page number 22 is there, Lord.
okay, yes, sir. Let us see what is the allegation against you. FIR.
My
Have you any?
lordship allegation against me is under section 21B of NDPS, Lord.
21
B.
B.
B, lordship.
Okay. Why anticipatory bail or pre-arrest bail in and
No, it's in regular bail also.
regular bail?
Regular bail also.
Okay.
I'm behind the bar since 31st of August, lordship.
31st August.
31st of August, lordship.
So,
And
how many days
today
now?
will be 34 days, lordship.
Hmm?
34 days, lordship.
34 days.
Yes.
Oh, so what? 34 days.
Sorry, lordship.
34 days. Then what?
Then actually, lordship, my ground for bail are that there are severe irregularities in the prime documents, which are the FIR, the seizure, and the forwarding itself, your lordship. Here the time were different, your lordship. In every documents, there are times were different.
What was required?
From, may I take your attention to the FIR, lordship, page number 22.
Yes.
May I read out, lordship, the
Yes.
relevant part.
Hmm? Yes.
10 line from the top, lordship, the relevant part.
Okay.
In
Just-
meantime,
just a minute, huh?
lordship.
We'll read from the beginning. Let's wait, huh?
Then may I, lordship?
Yes,
It
please.
is today on 31st/8/2024 at around 11:30 hour, reliable information was received from our own source to the effect that one Sri Nayandip Deka Borua of Assam is likely to bring contraband substance, powder drug, from Assam to Bodumsa on a black Thar vehicle for further sale to the drug consumers of Bodumsa town. The received information was recorded in Bodumsa PS General Diary by GDE number so and so dated 31st/8/2024 and necessitated in section 42 subclause 2 NDPS. The information was intimated to SP, CLG and proposed police action. Thereafter, the information was shared with Sri Orling Ligo, ADC Bodumsa, Executive Magistrate Bodumsa, and requested to accompany police search team. On his arrival, I, along with Executive Magistrate Siti Sobilel Chetri, Siti Ongseng Omeng, Siti Moking
It's a constable.
Constable, sorry. So and so
It's okay.
rushed to Sunday Market area and placed police naka on Bodumsa Kharsang Road, NS 215 highway. Near Sunday Market, in meantime, Sri so and so were crossing the Naka point in their personal vehicle. As such, they were requested to act as independent witness to place to police search and seizure proceeding. At around 1410 hour, here lordship, I want to grab your attention to 1410 hour.
Yes.
The targeted black Thar vehicle was intercepted by the Naka team. After stopping the Thar vehicle, the driver, later identified as one Sri Nayandip Deka Borua, was informed about our intention to conduct his personal search and that of his Thar vehicle. Notice under section 50 NDPS Act was read over and served to him. After obtaining his consent, search was commenced. During the process of search, 7 numbers of blue color plastic soft case, 5 numbers of green color plastic soft case, and 2 numbers of deep green color plastic soft case were found inside the back door of the Thar vehicle. When the soft case were opened, orange and white color mixture suspected powder drugs was found packed inside the transparent plastic pouch. The recovered powder suspected was weighed on digital weighting device and found to be so and so and so and so gram. Total to be 177.09 gram. Therefore, the recovered powder suspected along with the Thar vehicle so and so number with key 1 mobile phone so and so driving license and vehicle register were seized in presence of executive magistrate and the independent witnesses. The search and seizure process was video recorded through the personal mobile of mine. Accordingly, said Sri Nayandip Deka Borua and the seized item has been brought to police station for further course of action. In this regard, yes, lordship. So here,
What is the name of the accused?
Nayandip Deka Borua, lordship. So here, your lordship.
Okay, the accused himself is the applicant.
Yes, also.
Yes, what do you want
So
to say?
here, your lordship, the informant, which is also an ASI from the same Thana, your lordship,
Yes.
who stated in the FIR that in 1410 hour they intercepted me with the black Thar vehicle, your lordship. And again, if we see the seizure memo, your lordship, which is from Annexa 4, page number 27, where that my same car has been shown seized in 1400 hour, lordship. 10 minutes prior to my interception. Page number 27 is the type copy, lordship, and the original was is page number 29. Seized around 1400 hour, the Thar vehicle, lordship.
Naturally, because
Lordship.
this FIR was also lodged only after completion of those procedures, isn't it? FIR was also lodged not immediately.
Lordship.
That was only after completion of the process only FIR lodged.
So
And
it's
then they,
1645.
at the time of entering the
1645 FIR time.
they must have naturally some mistake has to happen.
Okay, your lordship,
Not-
if you oversee this your lordship, that for 1410 hour when my interception was happening and when my car was seizure, it's 1400 hour.
Clarify.
So in the second part also, your lordship, where the contraband substance were seized, that's on 1430 hour, which is type copy is lordship 28. Now what happened here, lordship? The contraband substance who is allegedly seized from me, which is in 1430 hour, which I have categorically specified in my application from page number of paragraph number 7 to 10, lordship.
Para 7 of what?
Paragraph 7 to 10 of my application, lordship. I have categorically stated this fact, lordship.
You take this plea during trial, point it out,
Lordship, but
point it out, demolish the evidence of the prosecution.
lordship, no, I with this ground went to the trial court also, lordship. I with these grounds went to the trial court also, but trial court rejected my application, which is from page number 33, lordship.
What it says about the
Lordship,
timing?
Lordship, here, Lordship, the, as per this FIR, Lordship, 22, page 22, the today on 31/8/24, Lordship, 11:30 hours, information was received, Lordship.
Yes.
Lordship, and after that, Lordship, as per this record, Lordship, the arrest memo, Lordship, accused was arrested on the same date, but 1645 means 445, Lordship. And the FIR, Lordship, registered on 1630, 430.
Yes. And when the vehicle came, when the vehicle was
Lordship,
intercepted.
this is the lordship during course of lordship, they have the only lordship, they have information, lordship, regarding that certain.
Now, what is raising
Lordship.
is that the vehicle belonged to the accused was intercepted at
1410 hour.
1410.
Lordship.
Seized at
But then the
1400.
seizure was made at
1400, lordship.
before interception.
Before
The seizure
interception.
already made. What is
Lordship.
Seizure was done before meeting with the.
Lordship, after vehicle, lordship, lordship, they have.
See the timing, what is source?
Lordship.
Vehicle was intercepted at 2:15. 14?
1410, your lordship.
Oh, 14.
And vehicle was seized at 1400.
And see the seizure list. Seizure was made at 14 hours. So that means seizure was made before. What he meant, what he is pointing out. But otherwise, of course, this is because this FIR was lodged only after completion of all those procedures.
But your lordship, what I am trying to step. I'm trying to establish here that these all documents were made by the professional police lordship. This is not somebody who is the layman or who do not know the procedure. That's where the grave doubts were created, arises, lordship, because these documents
You
are,
have to submit this.
Lordship, here, Lordship. as
and
per
these
this
all are the
Lordship,
primary documents,
Lordship, I
lordship.
cannot go to the all the records, Lordship, but as per the list FI, Lordship, 1410, Lordship. As such, Lordship, at around 1410, the targeted black Thar was intercepted by the NACA team after
1410.
Yes, sir, 1410. No.
Yes, yes.
Yes, sir.
Now,
After
now,
that,
go,
Lordship,
now go to seizure list.
Please.
Lordship, maybe Lordship, it has take some time, Lordship. It's not that the other day, Lordship, the same day, Lordship.
Okay, so
It is,
let's just go to
Please tell me.
the seizure list.
Mention.
It takes time. You said it takes time. So now you see that time.
around 14.
It did not take time. It took minus time.
Lordship, this is actually by the scar cannot be Lordship, so visible, Lordship. I'll go to the records, check Lordship in the this Lordship.
And lordship, the section 52A was also not commented in the forwarding.
What the case there says?
1400.
In the
For
case
this,
diary
Lordship,
of
I have to seek clarification, Lordship. Lordship, on the basis of this only, Lordship.
Afternoon?
Lordship, it was at 2, Lordship.
At 2.
Lordship.
Okay.
Regarding this time, Lordship, time.
You just obtain instruction.
Lordship.
There is-
Otherwise,
there is
Lordship,
any
tomorrow, if possible, Lordship.
discrepancy and you want to
Lordship.
clarify from the police.
If tomorrow,
Tomorrow? Tomorrow?
Lordship,
Okay. So let's pray for by Miss Hage, Learned Additional PP. Please this matter to tomorrow.
Lovely.
No. Yes.
My Lordship. Here we have to file the affidavit of dusty service, Your Lordship. But the notice of the dusty service, we have lost that one. So I may be allowed to take fresh dusty service.
You have taken step by way of justice service.
Yes.
Serve.
It
No.
was served, but the notice, that notice receipt copy, we have lost that one.
Okay, that's why you could not file affidavit.
Yes.
Okay.
Lordship,
And
this
you-
time, Lordship, justice service may not be served, Lordship, because a criminal matter,
What is
justice
this?
service not to be. This
Yes.
criminal revision petition. It should be through the OCPS or the concerned, Lordship.
Okay, Miss
Tirimi.
Learned Counsel for the petitioner. Also have Miss L. Hage. Learned AD people. Staff. Miss Limu submits that although the petitioner has taken up steps upon the respondent by way of justice service, however, the copy of the receipt copy has been lost, hence pray for some more time. Ms. L. Hage submits that since this is a criminal revision petition, justice cannot be allowed, and submits that the notice has to go through
To the concerned OC.
for the concerned OCPS staff. Okay, accordingly, the notice upon the respondent
2 and 3.
2
and 3.
be served through the concerned OCPS. Okay, stop. Within a week from today.
Okay.
Okay, list this matter after 3 weeks. Okay.
Bless you.
Yeah, ma'am.
Yes,
In this case, Mr. D.K. Deori was appearing, my lord, for respondent, and mistakenly their name has not been mentioned in the course list. My lord, may see the first order, 7/8/24, my lord.
7/24.
8/24, my lord. Yes, ma'am.
No. So when do you want? You said.
No, no, man. This cause list, my lord, in the cause list, my lord, the counsel for the respondent, my lord,
Okay,
his name has not been
respondent 7,
reflected.
8.
Yes, ma'am. Respondent number 1 and 2, my lord.
1 and 2.
Yes, my lord.
Earlier appeared.
Earlier appeared, that's why, my lord, 7/8/24, order dated 7/8/24, my lord.
You have furnished.
Well, yes, well, in the cause list, well, the name of the private,
Okay.
name of the
Mr. Preacher, Land Council for the appellant, star. No one appears on behalf of the respondent. Mr. Preacher submits that they appeared earlier.
Yes, ma'am.
Mr.
The registry
D.K.
has
Deori appeared
mistakenly
earlier, however, his name has not been reflected in the course list. And
Registry-
some is that.
Registry will be directed.
Due to which the land council for the respondent is not appearing. Therefore, reflecting the name of the land council for the respondent in the course list. Okay. Let the name of Mr. D.K. Deori be reflected in the course list as the land council for the respondent number 1 and
1 and 2.
Okay. Let's pray for list this matter after 3 weeks.
My lord. God bless you.
Your service upon respondent number 2 is still awaited.
Hmm?
Service upon respondent number 2 is still awaited, Lordship.
Okay.
Your Honor, I'm appearing for behalf of MK Singh,
And casing is for? MK Singh is for petitioner.
petitioner,
Okay. Mr.
C. Peter.
Land counsel for the petitioner. Miss El Hage, Land AVPP is also present. The office not dated 1/10/2024 reflect that the service upon the respondent number 2 is celebrated in view of the above. List this matter after 3 weeks.
Lordship, this I is for delay condonation.
May I please, your lordship, I am for the respondent number 1.
You
We
are
are
for
filing
respondent number 1.
objection today, your lordship.
Hmm?
We are filing objection today, your lordship. Filing is under.
How many days of delay?
This is a 501, Lordship.
Oh, 501.
This is an ex parte judgment against the ex parte judgment, Lordship.
Ex parte judgment. Then I think delay wise to object.
Lordship, there are grounds.
It was ex
We
parte
have-
judgment. Ex parte judgment.
Ex parte
Order or
judgment, yes.
judgment?
Ex parte, there was an ex parte order, then the judgment came, Lordship.
Okay.
Since we didn't had knowledge about the proceeding, and then after there was an ex parte judgment against us.
In any case,
Yes,
under
Lordship.
such circumstances, has
Lordship,
to given an opportunity. to
And
protest.
Lordship, our Guwahati
They have duly, notice was sent. They have refused to.
Anyway, if they want to file, let them
Yes,
file. Let us see. Okay.
Okay.
You are appearing for the first time. No, earlier also.
Earlier, Lordship,
No,
they
we are
appeared in
filing today.
January
We
or
are
February.
filing- We will serve copy just now.
No
We
issue.
will serve
You are
today.
filing.
Yes, today.
Okay. Mr. V. Jammu, Land Council for the applicant and stuff. Mr. A.K. Singh, Land Council appearing on behalf of the respondent number 1. Submits that he has filed affidavit objection to the itself and a copy not yet served. Okay.
I am serving, Lordship.
Okay.
After few minutes, I will serve.
However, the said objection is not on record. Stuff. In view of the above, list this matter after 2 weeks.
Lordship, since there is a execution petition against me, Lordship, this matter may be fixed on 24th of October.
24, okay. It's grateful by the Land Council for the petitioner list this matter on 24th October. In the meantime, Mr. Singh, A.K. Singh, furnish a copy of the objection to the Land Council for the petitioner during the course of the day. Okay, during the course of the days only?
Yes.
Okay. Then only say Mr. Singh shall furnish the copy of the objection to the Land Council for the applicant during the course of the days. Okay.
Lordship, I'm for the petitioner on behalf of.
You are for?
Yeah,
The
petitioner.
petitioner?
Yes.
Appellant?
Yes. On behalf of Titorum.
On behalf of?
Titorum.
Torum.
Torum.
Yes. You are appearing for the first time?
Yes, my lord.
Okay.
I'm for the defendant number 1 and 2.
1 and 2?
Yes.
Okay.
I have to file a counter affidavit.
Okay.
So
You are Mr.
Entaro.
Entaro. Your name is not there?
No.
Appeared on behalf of Mr. Tito Runani Council for the appellant staff. Mr.
Tipahi.
T.
Tempahi.
Hmm?
Tempahi.
T. Pagi.
Pahi.
Pahi.
Yes.
Who appeared on behalf of the respondent number 1 and 2 by filing wakalatnama and prays for some time to file objection. So, prayer allowed. List this matter after
4 weeks.
4 weeks. Okay.
Obliged.
Hello.
My lord, I am for the appellant. You are for the appellant. Okay. Mr. Keposi. Keposi, Land Council for the appellant is present. The office notes dated 7/9/2024 reflect that the service report upon the respondent number 3 is still awaited. Who is respondent number? Okay, this is okay.
Respondent number 2 is
Yes.
your lordship,
Victim.
victim.
Okay. What do you want? You want to take first step or?
One is the state.
That is true, but what do you, these were, the step was taken.
Yes, step was taken,
Okay. In view of the above, list this matter after 3 weeks. Yes.
May it please your lordship. Lordship, item number 19 is my IA for stay vacating, my lord.
Before Mr. Sharma starts, I'll tell him, I have put in 35 years of practice, sir, and I'm a senior advocate for last 15 years. My lord, my senior told me first thing that it is better to lose a case than to lose your face before the court. My lord, on 9th, I was here. I was stuck up in the traffic. My lord, the matter was taken, posted for 23rd, I suppose. Yeah. 23rd, no? And then, my lord, I made a mention before the honorable court in the chambers. And my lord, that the matter was fixed on 16th. Now, while I was in the airport, I had cancelled all my cases for Delhi. Mr. Sharma rang up my junior and said that I am seriously ill. And please request your senior not to come to my lord, in all fairness, assuming, my lord, I cancelled my tickets. Because despite the fact that all cases in Delhi were stuck up because I moved the circulation. Now, my lord, Mr. Sharma's junior, local council, I don't know who is there, and my friend, Mr. Jamo, they were both sitting outside the court waiting for the number. Mr. Sharma made a request online through video conferencing, out of turn request, and got the matter adjourned for today. After telling me that he's not well, he'll not be able to argue the matter.
My lord, there is a serious
My lord,
allegation
this
that's been
is
laid
in
against
fact
me, my lord.
shameful. It is not
No, my
only
lord, this is,
unprofessional, it is
I would not accept
misconduct.
it, my lord. My lord, just hear me once. My lord, this is
He
absolutely,
himself,
no, my lord, this is absolutely not required to mention all this because Mr. Jamu itself
yes,
told
it
me,
is.
their local council, to fix the matter on third
You
rather than on
insult
first.
a senior advocate, professional insult.
Please, one at a time. Just a minute, huh? What is this case about?
My lord, it
My
is a
lord,
very
this is,
simple case, I'll tell. This is a
my lord,
dispute
it's
between
my
husband and
IA,
wife.
my lord, let the
My
senior
lord
council
has
be at
been
least
kind
explain
enough
the court.
No, one at a time, please, please.
Now, please,
Just wait,
I'm for
wait.
the petitioner, in fact.
Just wait, huh?
My lord, the main matter, in the main matter, I'll just point out two things. My lord, what happened is, the complainant here, for whom Mr. Sharma appears, he is my father-in-law.
Just a minute, huh?
He is my father-in-law.
Complainant means?
Complainant, the person responding number 2 and 3. I suppose 3 is. Kya naam hai? 3 hai na ye? He is responding number 3. He is lodged the FIR. Now, I'll only point out, my lord, will be
Just a minute, let me confirm the party.
respond number 2, yes, Vinod Kumar. He is the father-in-law.
Petitioner, how many? 6 numbers.
There are 6 of us. My lord, every person whose name was printed in the wedding invitation card, without knowing them, without knowing anything about them, they have made us all accused. And they have made us accused. This person, the complaining, my lord, he was holding the senior most position in the electricity board in Arunachal Pradesh, in NIPCO. And my lord, yesterday, Honorable Supreme Court has directed for termination, for dismissal of such an SHO in Uttar Pradesh. Yesterday only, that judgment will pass it on, my lord. My lord, may kindly see what has happened here is, I'll not take more than 4 minutes, 26 seconds. My lords, November 21, the marriage was solemnized. This is the one. I will pass on one copy, my lord. My lord has been kind enough to grant stay in this order. It was my lord's order.
Just a minute. So here, how many applicants are there?
5 or 6, 6 of them.
6.
My lord. My lord, only
And
one.
respondent, how many?
4 respondents, my lord. The 4th is a pro forma respondent. He is the co-accused. And he is the person again whose character has been assassinated by this complaint. Only because he was manager of the hotel and the wife, his complainant's daughter-in-law and son had stayed in the hotel.
So this is
My lord, the kindly
this
come.
IA is for?
Pardon?
This IA is for?
My lord, this
This is
IA
for
is filed by me, my lord.
So I say,
Against
my
the
lord,
stay vacating, my lord.
Just a moment. My lord, order sheet dated 9/9/24, may kindly see.
May it please your lordship.
9/9/24, clearly it was said that it will be heard finally.
Let me acclimatize.
My lord, my clients are staying 2,000 kilometers away from Arunachal Pradesh.
Just a minute.
They had never heard the name of Bhalapon named in the FIR. And nobody is named in the FIR. My lord, just for that. My lord, the background, may I submit the background, my lord? Within a minute, my lord, I have submitted.
Yes, what is the background?
Yes. My lord, November 21, the marriage. My lord, we say that wives torture the husbands with unnecessary litigation of 498 and dowry.
Wife torture?
Normally, it is the impression. Supreme Court has also observed. Here, it's just the other way around. Wife and her entire family, even grandfather, against them, they are being called by Bhalupong police station, my lord, for recording statement from 2,000 kilometers. 86 years. He's 86 years old. My lord, may kindly just go through the index, my lord. The synopsis. My lord, November 21, the marriage was solemnized.
Okay.
It was solemnized in Delhi. Then, my lord, they had a wedding reception in Guwahati because he is chairman of NIPCO. Then, my lord, May 22, what happened, my lord, is, my lord has got that synopsis, my lord?
Yes.
May 22, the respondent number 3, the husband went to Canada and started living in a relationship with another. Now, 28/11/22. My lord has got it, my lord?
28.
Within a year of marriage, the petitioner number 1, the wife, filed a detailed complaint to the SSP Raipur, Chhattisgarh, and Mahila Thana, ladies, women police station. 28/11/22. It is very interesting, my lord. They
Petitioner
immediately.
number 1 is? Husband or
The
wife?
wife,
Wife.
the daughter.
Okay, yes.
She. Then, my lord, the lady filed the detailed complaint. The police at Chhattisgarh calls them for if mediation is possible. They get to know, my lord, that the wife has approached the police. Now, my lord, on 28/11, I'm sorry, 4/1/23, an FIR is registered against them.
Where?
Against this is in
Where?
at Raipur in Chhattisgarh, 2,000 kilometers.
Okay.
Now, my lord, this is under 498.
They belongs to otherwise
to Raipur,
Chhattisgarh.
Chhattisgarh. Yes.
Both.
The
Both
wife's
wife and husband.
family. Wife's family.
Wife's family.
They are from Chhattisgarh. The boy is from Gurgaon, Delhi.
Okay. Okay.
And the report is lodged at Arunachal Pradesh, Bharatpur.
Yes.
Very interesting.
Hmm.
Then, my lord, in April 22, respondent number 2 stayed with his family at Nipko guest house because
Who is
father was
respondent-
the
Who is respondent number 2?
husband.
2 is husband.
2 is husband.
1 is wife.
One is respondent number 1 is the father of the husband. Very interesting, my lord. Husband doesn't lodge any report. Mr. Gentleman, husband's father lodges the report.
No, just a minute. You said that November 21, marriage of petitioner number 1.
Petitioner number
and
1.
respondent number 3.
Yes. Yes. She was married to respondent number 3.
Okay. And
Petitioner number 1.
representing- you are-
Petitioner number
you are
1.
for- you are for?
I'm for the petitioners. I'm for all the petitioners. The wife's family.
Wife's family.
Yes. Now, my lord, what happened is May 22, I visited Arunachal. The wife visited Arunachal with respondent number 3, husband and wife. This is in May 22. Interestingly, my
Petitioner
lord.
number 1 visited Arunachal. Okay. Yes.
Then, my lord, on 17/5, this is the allegation that interesting balance. Arunachal Pradesh, I have traveled across Arunachal. My lord, such a beautiful place. What happens is the father, after 1 year, lodges a report, my lord, that after having
So who stays here in Arunachal?
nobody stays in Arunachal. This is what I'm saying. The wife's side is in Chhattisgarh.
So, but
Husband's
wife
side,
visited Arunachal.
they visited Arunachal for a honeymoon sake of a thing, I don't know. Because father was chairman of NIPCO. Director
Where
of
the
NIPCO.
father stays?
Then, my lord,
Where the father stays?
he is in Gurgaon now. Huh?
Who stays in the place where the FIR was lodged?
Nobody, that's what I'm saying, my lord. And my lord, one thing. My lord, can you bear with me for a moment, man? After they got the message of criminal case having been registered against them in Chhattisgarh, then they woke up from sleep.
Who is the informant here?
Why?
My lord,
why
I'm
is
the
it-
informant.
Petitioner.
I am representing.
Here the father-in-law. Now he lodges the report.
Where do the father-in-law stays?
My lord, and presently, my lord, he stays in Gurgaon, my lord.
Just a minute.
He's in
My lord.
Gurgaon. He's in Haryana. He's in Haryana, near Delhi.
Haryana.
He comes to Alupon. He comes to Alupon. And whatever transpired was between husband and wife. Husband doesn't go to any police station for 1 long year. After 1 year, the father comes to Alupon to lodge a report.
When the incident is alleged to have taken place?
Before 1 year. That is, my lord. That is why I was inviting my lord to Adikship
So the FIR was lodged after?
1 year.
After
More
1
than 1 year.
Okay.
And incident
And,
is, my lord,
registered
incident
under-
is, you know what his name is written? Page number 120 of my application. My lord, it is shameful to narrate that in the open court. My lord, he said.
Also had Ms. L. Hage, non additional public prosecutor for the state of AP, and Mr. E. Omo, Land Council, appearing on behalf of respondent number 2 and 3. Yes, 2 and 3. Start, huh? Omo and Mr.
SP Sharma, my lord.
Okay. 44. 44. Respondent number 4. Start, huh? Para. This L. Hage submits that, prays for some more time to produce the updated
Yes,
case diary.
Lordship. So it may be reflected that the courtship action, Lordship, it not be, Lordship.
Let us
yes,
clarify, let us
Lordship.
clarify. Courtship
Lordship.
action is just, if it is a non-bailable offense,
Lordship.
in any case,
Lordship.
if they appear, you just show them, arrested and release them, finish.
Lordship.
You have filed objection, say.
Yes.
Okay.
Investigation has told difficulties that they are not cooperating. Some of them are not cooperating.
Just a minute, before that, in the instant case, the updated CD would be necessary for adjudication of the case. Accordingly, Ms. L. Hage paid for some time to produce updated case diary. CD. Start. The prayer is allowed. List is matter on.
My lord, can it be on 12th of November?
My lord, we are on 3rd of October now. Any short date can be. My lord, may
My lord,
kindly
there's
imagine
puja holidays 2 weeks, my lord.
just, no, just a moment. My lord, may kindly imagine the mental agony that the girl and her family.
No, when
It
do
is
you
not,
want?
Not
Just-
only protecting us, but we are not criminals.
They
are not named in the FIR even. Nobody is named in the FIR, my lord. My lord has seen the
That is
FIR.
why, when do you want?
154, section 154 may kindly be read.
That is why we're going to consider on the next date. So when do you want?
Why November?
Give date.
Just in October itself. October till 20th you have the holiday. After 20th, any date, madam?
My lord, may
But,
please, my lord, I have a problem on the
I'll
3rd week
again
of
make a
October.
request, my
But
lord.
again,
If my
they will
lord is
have a
kind enough
problem.
to pass the orders of merits, my lord.
My lord, may it be on the November, my lord, because my lord, we have a problem on third week and the 4th week, my lord. There are matters here, my lord, the division bench, my lord.
When do you want?
Not immediately after the vacations, Lord.
After vacation,
October
October 30.
21st October. 21st October would be fine, my lords.
21st October?
Or rather, Lord, I would
My
pray
lord,
that the petition
my
be
lord,
decided immediately.
my lord, there are some division bench matter in the.
No. Will it?
Lordship, first week of November, Lordship, because in the
First-
puja vacation,
We'll
Lordship.
file the written submission and close the matter.
Okay.
First week of November, my lord.
November.
Lordship, first week November.
First week means date, give date.
My lord, fixed date may kindly be given, my lord.
When?
Maybe on 6th.
6th. Okay.
Either
6th
1st of November or 5th or 4th of November
Okay,
or 8th.
6th November. Okay.
Much obliged, my lord.
For which day?
My lord, may I make a mention, my lord? 6th of November would be wasting my 3-4 days. Because
6th.
My lord, so any Friday or Monday would be fine, my lord. So that
Friday.
I
Give
get
date.
to,
Well, that is why I'm asking you date.
I said, my lord, 1st November, 4th or 8th, any no.
My lord, on 8th of November, my lord, if my lord, my 8th of November, that's a Friday, because Lord himself has said that 8th is not a problem.
Anyways, my lord, any date, I don't want to argue on these things now.
Let it
Any
be
date.
8th of November, as per convenient.
And, my lord, may interim relief may kindly be continued, my lord.
No,
And-
Lordship, no relief, Lordship. Otherwise, Lordship, this case study also, Lordship, it will have. On the updated case study and the investigation can be, should be, Lordship,
said
carried
that
out,
they
Lordship.
cannot proceed. Investigation has not been stayed.
In the meantime, the interim order dated 9/9.
Yes.
Passed on 9/9/2024 shall continue.
Not would it be possible to observe in the order sheet that on the next hearing it will be listed for final hearing? Lord? It will be decided. The small matter, Lord, where the accused persons are even not.
It's there already, it's there already. If the materials are available, it will be disposed of. Okay.
Or not, we may file a written submission before your last.
Yeah, that will be fine. Okay.
Much obliged, my lord. Much obliged. Much obliged, my lord.
Then 4. Okay, we'll resume at 2 then. Yes.
May I please, my lord? My lord. Last occasion, I have brought some citations, it supported my case.
Okay, this is that,
Yes, my lord.
Quashing petition.
Yes, my lord. So, my lord, now I have.
What was the, yes, this is the case where PDPP Act.
No, my lord. Only 324 IPC is there, my lord.
324.
Yes.
Yes,
So,
previous.
so this is joint petition filed by the accused, victim and the complainant. So.
So pending before which court?
Learned Court of JMFC, my lord.
JMFC UPR.
Yes, my lord.
324. What is the punishment?
Punishment, maximum punishment 3 years, my lord. It may extend to 3 years or with fine or with both. For 324 IPC. So, lordship, in my support, I have wrote some.
Yes, what it says.
Gensing, I have also Gensing versus
Para?
State of para number, my lord, 57, 59, 61. Gensing case, my lord, 57, 59, 61, my lord, operative para. This case, my lord, accused was convicted under section 420 and 120B of Indian Penal Code. And
After conviction?
Yes, after conviction, the honorable accusers went to High Court, Honorable High Court of Punjab for quashing of FIR.
After conviction, it is appeal only.
No, my lord, he was filed after settlement. After conviction, he was settled the matter with the complainant or the victim. And then he has filed criminal petition before Honorable High Court. Honorable High Court has dismissed the quashing petition. And thereafter, he went to Honorable Supreme Court. And Honorable Supreme Court third bench has given this citation judgment. And since the matter is compromise between the accused and the victim, so
what was the offense
judgment was
in that case?
420 and 120. He was
420 and 120B.
Yes, criminal
420, that
case.
is. It is not affecting the society.
Yes.
So here the criminal case 324 involves with it is against the society. So what is your submission?
$49, lordship.
Yes.
Lordship, it is stated that that the accused has alighted from his vehicle and came towards me and assaulted me by a bamboo stick, boxing and kicking by saying, "Why are you dropping shutter in the road?" Lordship, here, lordship, as per this, lordship, his statement, lordship, nowhere it is mentioned that he is being, lordship, threatening with some weapon or like that, lordship. As per his, in this statement of a victim, lordship, it nowhere is reflected that he is being threatening with some lordship weapon or like that, lordship. Only bamboo stick, lordship, is in his deposition, lordship, in his 161 statement.
My lord, I have additional 2 citations I have given.
Moreover, lordship, as per the lordship, this is joint application, lordship, and they have already settled, lordship, and they are being, lordship, I have no, lordship, there, because as per lordship, it says 324, lordship, they have their, between the 2 person, lordship.
So what is this, Mr. Ram?
Yes, my lord. Second citation is, my lord, second citation, my lord, para number 8 and 9, my lord. Gold Quest International Private Limited versus second citation. This is recent.
This is matrimonial in nature, not the.
No, my lord, this Gold Quest International, this was not matrimonial. This was some transaction was there between the
Money
company.
transaction is always between two persons,
And
two individual persons.
section.
Money transaction.
Yes.
So
my
let us
lord
say this 57, yeah, para 57. What it says exactly? Let us see.
My lord, in case of Gyan Singh, my lord, 57, then in Gyan Singh, the Honorable Apex Court has clearly defined the inherent power of Honorable High Court under Section 482 CRPC, and also stating about the matter which compromise right between the parties. So Honorable High Court may cause the criminal petitions or FIR or complaint.
You said that they are the informant, relatives.
My-
Where have you stated?
Informant and the accused, they
Where
are
have, where
neighbors.
have you stated?
Yes, my lord, I have somewhere stated. They are neighbors as well as relatives.
Neighbors and relatives where?
Yes.
Para?
Since, my lord, more particularly, I have. There are 5, my lord, I have here. Victim and the woman in the presence of relatives. Accordingly, opposite case has been settled within the parties. But,
No,
certain
victim is not a relative.
a victim is in fact not a relative. He is an employee of.
How the victim is a relative?
My lord,
labor.
victim is not a
Outside.
relative. Yes.
This is
My lord, victim is labor employee of the informant, and that is petitioner number 2 here in my lord. So, my lord, since they have mutually settled and whatsoever whatsoever being caused by the victim was accused as compensated.
The case has, you say that the case has, what is this? There is not a good matter, so. Who submitted this one? Achin Gupta?
Yes, my lord, this is Achin Gupta is also recent judgment by Honorable Apex Court. This is 2024, my lord, judgment.
Okay, then para? Yeah.
Para number, my lord, 35, 36, and 41, my lord. Achin Gupta versus State of Haryana. This is recent settled mutually. So in that case, if the crime, the commission of offense is petty offense, so Honorable High Court may cause the criminal petition, FIR or the trial proceedings. And my lord, Section 324 is petty offenses, but Honorable Apex Court also observed that the punishment which is serious nature in offense, rape, like murder, rape, may not be caused by the Honorable High Court under Section 482. Problem with Torres, so I cannot read out the operative person my notes. I have some difficulty to communicate.
Okay. Or Mr. Kanra, counsel for the petitioner. I also heard Ms. Alhaji, line additional PP for the state stuff. This is a joint petition filed under Section 482 of Code of Criminal Procedure 1973, praying for quashing of the FIR date is 01/04/2019.
Yes, ma'am.
The FIR cannot be at this stage. Charge sheet trial also started.
Yes.
Hmm. Leave that one. Yeah, question after.
The course title first, GR number 218/19.
Where have you mentioned GR?
Course title, madam. (218/2019).
Was of FIR numbers and so on. In the same petition.
Yes.
Our petition, they have corrected by hand, they have lordship corrected.
No, it's not there.
Madam, maybe I have to.
Not corrected.
Written. I duly apologize.
GR number?
200.
Now, where do we find inside it? No, file number inside the petition? Inside the body of the petition.
My lord.
Have you? Who allow you to correct it by?
My lord, before filing of this criminal petition, GR number was not found. Then after filing and then filing of meeting of this petition.
Without any order, how can you correct by hand?
My lord has directed to collect the GR number. So thereafter we have collected the GR number from GR branch.
Then who asked you, who told you to insert and not in the court copy?
My lord has directed to collect the GR number, if I'm not mistaken, Lordship. My lord, in order number.
It has to be on record only.
My lord, order dated 18/7/24, my lord. By this on record. 18/7/24, Lordship.
And trial court cannot proceed without numbering the case. This is a basic thing.
My lord, it was not in charges, so thereafter, when filing this criminal, Lordship has directed to collect the GR number. And
now it is pending before the court only.
Yes. So Lordship was directed, then we have
in the court, whether the charge framed against accused?
Learned judge.
Yes. Were the charge framed?
Yes.
See?
In the record, lordship may find lordship in the record.
GR number.
Record, lordship may find lordship in the record.
No, it is not there on record, what I'm saying.
Oh,
so
record.
later on, I have pointed out to collect the GR number.
Yes.
And they have to incorporate in the course title or in the body of the petition.
LCR has called for lordship. LCR should be there, lordship.
How do we write from the LCR proceeding?
Yes.
They have to mention the number.
Lordship,
Can we go beyond the plea?
Lordship, yes, lordship. In the order dated 18/7, lordship, your lord.
Order is not the pleading. This was only just asking him to collect.
Yes, yes, lordship.
You have to make a prayer to pass the GR number. Unless that is
I move this criminal petition.
then in the prayer also you have to mention GR case, because ultimately we are trying to quash. This court is going to quash the GR number, not the FIR. FIR can't, because now after filing of charge sheet, the case filing of charge sheet, charge also already framed is before the court only. You have to incorporate here. Write the GR here. Unless there is a prayer in there. These are the basic thing, Mr. Ram.
Yes.
unless there is a prayer, unless there is a number, against which order, against which proceeding we are going to pass?
I tried to correct that GR numbers.
Passing of the GR number, what number you said?
218.
2
19.
in the course title also?
Yes, I have already written.
No, it is not there. GR number so and so, huh? Arising out of which PS case?
My lord, remove PS.
Arising out of remove PS case number. Miss. Remove PS case
My
number.
lord, PS case number 13/19.
13/19. Under section.
Under section, initially it was 320, but there are charge sheet is on section 324.
GR number 218/2019, huh? Arising out of the PS case number 13/2019 under section 447, 328 IPC. Start, huh? Para. Who is the informant?
Well, petition number 2 is
number. Okay, one is
accused.
Accused. Okay. The petitioner number 1 is one Sri Tana Tagi is the accused, and the petitioner number 2, Sri Gyamar Takar, is the informant in the above GR case number 2019, arising out of the PS case number 13/2019. 2019 under section 447, 324 IPC. By filing this petition, by filing this joint petition, the petitioner number 1 and 2, the petitioners, okay, the petitioners prays for setting aside and quashing off the said GR case, GR number 218/2019, arising out of PS case number 13/2019 under section 447, 324 IPC. On the ground that the parties have entered into. Where is the agreement you say?
My lord, page number 64, annexure C series, annexure C.
Parties have already settled the matter amicably outside a court. And the informant has no more grievances against the informant. Petitioner number 2 has no more grievance against the accused petitioner 1. Para. It is submitted that. Where is the FIR?
The FIR is in my petition. Page number 12.
Annexure Land Council for the petitioner submits that. The case of the case of the petitioner submitted by the Land Council for the petitioner is that on this is on 1/4/2019.
Yes.
So this, okay, 19. The petitioner number 2 laws a written FIR before the OCPS Demo. Against the petitioner number 1, inter alia alleging therein that the accused petitioner number 1 has physically assaulted his neighbor, one Mr. Ranjan Nath, and on just a minute, sir. Ranjanath, start. That the petitioner number 2 tried to compromise the case with the petitioner number 1. However, the petitioner number 1 refused to compromise and instead he brought a lethal weapon within the petition to the beating with bamboo stick, kicking and boxing, boxing and slapping the victim. Stop. It is further submitted that based on the above written FIR, the police has registered a case against the petitioner number 1, being Doimuk PS case number 13, 2019 under section 447/323 IPC and investigated into start. It is further submitted that after completion of investigation, the police has submitted the case into charge sheet against the accused petitioner number 1 under section
447
for offense under section 447 from 323 IPC.
324.
324.
Yes, which
Okay,
is
324 IPC. Stop. So this agreement is before the when it came into when it was settled
on
5th January.
Yes.
Sorry, 5th February. When the case was when the charge was framed against the accused?
No charge was framed against the accused on 16 May. 16 May
May
23 years.
23.
No, my lord, 2 to
2023.
2 to 23. Yes.
Okay.
2 to 23.
Okay. The Learned Trial Court then frame a charge against the accused number 1 for offense. The Learned, this is JMFC.
Yes,
The
JMFC.
Learned JMFC then found on being found prima facie case against the petitioner number 1, accused petitioner number 1 for offense, for commission of the offense under section 324 IPC, frame a charge against the petitioner number 1 under the said section, the said offense. Start. Paragraph. The Learned Counsel for the petitioners. In the meantime, during the pendency of the trial, the petitioners number 1 and 2 out of court deed of settlement on 5/2/2024. Start 24 start. The terms of the said deed of agreement includes that as per the said terms, as per the said agreement, the parties have amicably settled the matter outside the court. And accused petitioner number 2, petitioner number 1, sorry, the petitioner number, not accused, the petitioner number, the informant petitioner number 1 has pardon the accused petitioner number 1 and the petitioner number 2 informant has undertaken to withdraw the case from the court. Since he has no further grievance against her, accused petitioner number 1. Stop. Whether this agreement copy was presented before the court? No.
No, yet not. Because section 324 is non-compulsory.
Whether it was informed,
Yes, it's important.
then
In
what?
regard to settlement.
Okay. It is submitted that the said agreement deed, with the said agreement deed, the learned trial court was informed and made prayer for compounding the case. However, since the offense charged against the accused petitioner number 1 was non-compoundable, the court, the learned court, and since the learned court has no power and jurisdiction to compound a compoundable case, and the petitioners filed this for compounding of the offense against the accused petition number 1 under section 424. Stop. The Learned Counsel for the petitions that since the case has already been settled between the parties and the aggrieved and the victim has no more grievances against the accused petitioner number 1, the further proceeding of the case, above GR case, before the learned trial court, under the circumstances, would be a futile exercise, thereby, and it would be a wastage of court's precious time. Hence, pray for compounding of the case and setting aside the trial proceeding before the trial court. Stop. Miss Elhage, learned additional people. We have not filed any objections.
Lordship.
Okay.
It Lordship, that if the chances of conviction is futile, Lordship, then it may be cause Lordship.
Is produced this is
It's called by registry, Lordship. LCR is called by registry.
okay. Okay. While referring to the file code record, submits that since the parties, since the aggrieved stroke victim and the accused has amicably settled the matter between them, and as the aggrieved stroke victim has no further grievances against the accused petitioner number 1, under the circumstances, the further proceeding of the case, under the circumstances, the conviction of the accused petitioner number 1 is remote, and in that view of the matter, the further proceeding of the case would be only pending for a futile exercise and an abuse of the proceedings. She has no objection if the case is founded and a case is compounded stuff. Hard both the land council to the parties. Also, I have also perused and considered the available documents on record stuff. It appears that the petitioner number 2, informant. What is this? The petitioner number 3 is also there.
3 is a victim one.
Okay,
Three is
we
a
have to
victim.
include that. In that, no, petitioner number 3 is the victim. No? Okay, then we have to include in wherever the petitioner number 2 is there, we have to include 2 and the 3. Okay. It appears that the petitioner number 1, the accused petitioner number 1 has physically assaulted the petitioner number 3, and on his behalf, the petitioner number 2, being the employer of the petitioner number 3, has lodged a written FIR before the OCPS Doimo, which was registered as Dono PS case number 1319 under section 447, 326, and 3 IPC stuff. It also appears from the records that it is also discernible from the FIR itself that before lodging an FIR, the informant petitioner number 2 tried to settle the matter amicably with the accused petitioner number 1. However, the petitioner number 1 having refused, further tried to assault the petitioner number 3, due to the said misunderstanding, the case has been registered. The above PS case has been registered. Stop. It also appears that subsequently, the petitioner number 1, so petitioner number 2, informant, the petitioner number victim, and the petitioner number 1, accused, has amicably settled the matter out of court by executing and executed a deed of settlement whereby the petitioner number 2, informant, and the petitioner number 3, victim, has clearly indicated that henceforth they do not have any further grievance against the accused petitioner number 1, and they also expressed that they want to withdraw the case from case against the case pending before the case against the accused petitioner number 1 pending before the Learned Court of Judicial Magistrate First Class, UPR. Stop. The said agreement, sorry, the record also reveals that the petitioner number 2, informant, the informant petitioner number 1, informant first, informant petitioner number 1, and the accused petitioner number 2 are neighbors and they are also a relative staff. The record also reveals that, sorry, the agreement of the said agreement. So on perusal of the said agreement, it also reveals that the case has been settled between the parties in order to maintain peace and tranquility between the parties in the locality. In view of the fact and circumstances stated above, it appears that under the it appears that since the it appears that even if the case proceeded for trial against the accused petitioner number 1, no future result is expected. Under the circumstances, it would be a futile effort, a futile exercise, and would be a futile exercise and would exercise and amount to the wastage of the precious time of the court. So in this regard, then the learned counsel for the petitioner in his support has taken a reliance upon the following so and so. This you report. Which one is relevant for you?
My lord, I'm Gyan Singh versus State of Punjab and analysis. Very much relevant case. 2012 10 SCC 30
upon on the decision of the Honorable Supreme Court in case in Gyan Singh, Punjab and another reported in 2012 10 SCC 30333. Which paragraph you want?
My lord, 57, 15. Yes, my lord, it's a long judgment.
Paragraph 57,
bench judgment.
59 and 61, whereby the Honorable Supreme Court has directed for compounding of the non-compoundable case. Then observe that the case and the non-compoundable case also can be compounded in exercise of the section under 482
yes,
of CRPC.
Yes. Right.
So, in view of for the region is stated above, and in view of the submission made by both the learned counsel for the parties, I'm of the opinion that the case can be compounded. Compounded. And in view of the decision, in view of the decision of the Honorable Supreme Court in the above referred case, and in view of the agreement, in view of the submission made by both the learned counsel for the parties, and of the view that the case can be compounded. Accordingly, this the prayer is the petition. This petition, the criminal petition, is allowed. The proceeding of the case, not proceeding of the GR case, GR number 2019, arising out of the PS case number 13, 2019. Under section 324 IPC. Is hereby set aside and passed. The accused shall this was, huh? Yes.
May I please, my lord? My lord, here I am for the state respondent, my lord. My lord, on the first, a similar matter was listed, my lord. Petition number 123 of 2024, my lord.
Yes, it's 123.
Yes, my lord. It's a similar case from the same FIR, my lord. 124 of 2024. It was listed on I think first of this month. Day before yesterday, my lord.
It was listed.
Yes, my lord.
What happened there?
And my lord is, as per the order, my lord, order dated 1/10/2024, my lord. That case may be listed along with this case.
Okay, so when it's for?
After Puja break.
Okay, so is prayed for by both the Land Council for the parties. List is matter along with criminal petition number 123/2024.
This is 132/24, my lord. It will be listed along with
124. Okay. After Puja vacation.
My lord.
Okay.
Obliged, my lord.
Obliged.
31 is also there. 29.
Yes, my lord. Lordship was directed to.
Oh, sorry. 29. Yes, Mr. Bajaj.
Yes, my lord. This is Zell appeal, wherein I am amicus. Amicus here.
Okay.
So,
Service is awaited, lordship, upon as per number 2, lordship.
Service is still awaited.
I have received this paper book.
You have received?
July 2023.
Okay. So, but then the respondent number 2 is the
Respondent number 2 was not met as party.
So it was made. Subsequently,
Now,
it was made as a party.
subsequently it was met.
Okay, so the respondent number 2 is victim.
Victim.
Okay, so since the service report is still awaited, we can. By the way, what is this?
This is conviction under 307.
307.
And 25 of
Arms Act.
24 Arms Act.
Okay, so conviction for?
Yes.
307, 10 years.
How many years?
10 years.
10 years.
10 years?
Yeah.
Okay.
I have seen the records.
25 or okay.
Already, my lord, 7 years, 6 months have been already gone in the.
Okay, so under 30, what do you say?
307.
307, how many years?
307, 10 years.
As per the
Either
10 years.
life or
Okay, the minimum is 10 years.
minimum.
Yes, 307 minimum would be 10 years. 10 years or 10 years rigorous imprisonment for 307.
Yeah.
Okay, whether the minimum is 10 years or let us confirm. Where is it? IPC. Just a minute. It's there. No, which may extend to years, not minimum.
Imprisonment or other description. For example, which may extend to 10 years.
Which may
And also liability.
No, so it's so minimum is not prescribed. And then the 10 years for offense under 307. And so
As
the
well as-
1 years
1 year for 25.
25 1B. Okay, so it has to run concurrently.
Yes.
That is what 10 years. I think that can see. So who is the
Same is 1.
what happened? The victim is coming or notice was affected. If not appearing, we can just pass an order for appointment of legal aid counsel for the victim. Who is the victim? The which PS case? Which district?
This is Italian. NNDPS. NNDPS. Yes.
It will be difficult for the victim to come. Then we may have to go for a appointment of the legal aid counsel.
Yes.
Half of the victim. So it appears that you have stayed that stayed since 2022.
Yeah, 22.
And then when subsequently he was arraigned, by which order? LCR was called for since long back in the year 2022. Okay. Mr. Mbose, Lanet Amicus Curie. No. This is jail appeal.
Jail appeal.
Okay, Amicus Curie for the appellant. I've also had Ms. El Hage, Lanet additional PP staff. No one appears on behalf of the respondent number 2. As per the record, the service upon the respondent number 2 is awaited since long. It appears that
This is Italian.
under the circumstances, comma, the register stroke secretary the High Court Legal Services Committee, High Court Legal Services Committee with another bench is directed to appoint one legal aid counsel from the panel of the legal aid counsel for the High Court on behalf to represent the respondent number 2 victim. Let's say because they'll have to appoint and then these all weeks.
3 weeks.
3 weeks. They'll furnish after 3 weeks. Okay.
All right.
Okay. Yes. This is the mentioned one.
No, my lord, this matter is supposed to list today, but it was escaped in the main course list.
Okay.
It was listed on 1-3, my lord.
Hmm?
1-3 was listed on 1-3. Partly lordship has heard the bail application to obtain update case that
Just a
in
minute,
connection with the
This is in the
instant
course of case. No? I think there someone in some other case. I think. Okay. How long you have been inside?
Since 3 August, my lord. Since 3 August.
3 August.
Yes.
So how many?
Today is 62 days, my lord.
62 days.
Yes.
And what is the statutory period?
My
to
lord,
be spent?
maximum punishment here in the 21B is it may extend to 10 years imprisonment
10 to 10
or
years.
with fine of rupees 1 lakh.
Extend to 10 years.
Yes.
Not the mistake. Minimum is
It
not.
may extend to 10 years, my lord.
It may extend to 10 years.
Yes.
Okay. Now, what is the status? Whether the police has submitted charge into the case?
This is a status report.
Maximum is 60 days. You could have filed once IA or miscellaneous application. Then since he has spent 60 days and
Yes.
he is also entitled under 167 CRPC.
Yes.
Everything of the FSR report was.
Okay, so but charge is not yet
No,
filed.
not yet.
Since my lord, I have spent more than 60 days, so lordship.
Now
I have-
he's entitled. The trial court also can pass this order. Isn't it?
my lord, I am seeking regular bail of the accused.
It's all the same.
If lordship may consider on the ground the accused father who is along residing at Belize is suffering.
Mr. Enra, Rama, Land Council for the additional PP. So, by filing this application, by this application, filed under section 483 of BNS 2023, read with section 37 of ND Act. The petitioner seek regular bail. The petitioner is accused himself.
No, my lord, petitioner is
seek,
brother of the
regular
accused, cousin brother.
Regular bail to the accused, to the Tabago Gatong.
Yes.
Under section 21B stroke 29 of NDPS Act. 29, the maximum punishment is 29.
Confirmed, sir.
Para. The And the police has registered the above PS case number 133/2024 under section 21B 29 and stroke 21B stroke 29 of NDPS Act against accused or who else?
My lord, 3 accused was arrested in connection with the present case. One has already granted bail by the Honorable Session Court
Okay.
on 23rd of this month. Sorry, 23rd of
Accused
September.
along with 2 others.
Yes.
And 2 others. And arrested on which date?
3/8, my lord.
Arrested on 3/8/2024. Stop. And since then, the accused has been under the custody, police stroke judicial custody without release. Stop. Para. What is your prayer otherwise?
My lord, my ground is, my first ground is, my lord, doctrine of parity may be given, benefit given to me. My lord,
The Land
since
Council for the petition
co-accused has already granted.
submits that the
And
other
another is
co-accused,
medical ground of my father.
namely, who has been released?
Teli Beckham.
Teli?
Teli Beckham.
Beckham Teli.
Beckham.
Beckham Teli. Who was arrested along with the accused petitioner, present accused, has already been enlarged on bail. When?
My lord, on 23/9.
On 23/9.
By the special session judge.
2024.
23/9.
23/9/2024 by the learned trial court.
Other ground is, my lord, my father is seriously illness. I have enclosed medical document.
Hence, on parity, the present accused is also entitled to be released on bail. So it is further submitted. Another ground for seeking bail is that the mother of the accused is seriously ill and there is no one to take up except the present petitioner. Except the present petitioner. He is the only son.
Yes, my lord.
Okay. Who is the only son? He's the only son of the son, stop. Being the only son of his mother, stop. Healing mother, stop. Correct. The Land Council for the petitioner further submits that the maximum punishment for offense under section 21B is NDPS.
Rigorous imprisonment which may extend to 10 years, man. Rigorous imprisonment which may extend to 10 years. 21B.
B, which involves the 21B.
Yes.
Where the contravention involved quantity, lesser than commercial quantity, but greater than small quantity.
Intermediate quantity,
Greater than small quantity, okay. shall be with rigorous imprisonment for terms which may extend to 10 years and with fine. Stop, huh? The statutory period for submission of the charge sheet under the above offense would be 60 days. Stop now. However, so in the instant case, the accused was arrested on when? 3/8/2024. And 3/8/2024, and since then, more than 60 days has passed, but the police has failed to file charge sheet into the case till date, and hence under 167 2A also what is the correspondent case, correspondence section of the BNS. Do we have a BNS? What is the correct?
I have brought old one.
Yes. No, the BNS is
My lord, 187.
Bharatiya Nagar.
New BNSS.
Correspondence case. Correspondence case.
187. Section.
One 187. Section 167 2 Roman, then 1 bracket Roman 2, huh? And then stroke 187. Then to CRPC stroke 187 of BNSS 2023. What did I say? Entitled, huh? Also, the accused is entitled to be released on bail. Stop. Huh? So, what was your submission?
I have perused the case study lawsuit. As per the case study lawsuit, charge sheet had not been submitted lawsuit. Only the FSA report is awaited.
Okay. Sarah, Miss Planet IDPP. While referring to the case study and the status report, submits that
The case is still under investigation, Lordship.
Some state. The case is still under investigation. And she fairly submitted that the case has not yet, case is still under investigation and charge sheet has not yet been filed.
Awaited the FSL report, Lordship. We have sent for
As
FSL.
the FSL report is still awaited. Stop. She fairly submitted. She has fairly submitted that on expiry of the 60 days. On expiry of the 60 days from the date of arrest, if the police fail to charge it against the accused, the accused would be entitled to be released on default bail.
Lordship, but the recent judgment is there, Lordship. Even though, Lordship, the statutory period, Lordship, if the charge is not submitted, then the supplementary charges can be filed, Lordship.
Yes, that is from the long back. That can be, they can file charges.
Yes.
And if the FSL report is still awaited, he can mention in the last, keeping it open to file supplementary charges. That having not done, he is entitled. He has always, he has a right to file supplementary charges.
But Lordship, it may not be recorded from my side that bail may be granted.
Okay, so she has no objection if the bail is granted.
No, objection not also, Lordship. It's just my fairly submission.
Then, okay.
Otherwise, it would be.
Don't record it, then. Okay. Just in view of the above fact and circumstances and the submission made by both the Lana Council for the parties, it appears that the accused, what is his name, Taba Pratham,
Yes.
was arrested on 3/8/2024 in connection with the Itanagar PS case number 133/2024 under section 21B/29 of NPS Act. And although more than 60 days has expired since his arrest, the police has failed to file the case into charge sheet till date. Stop. Till date. Under the circumstances, if the police fail to file charge sheet into the case within the stipulated period of 60 days, the accused would acquire an indefeasible right for consideration for his release on bail. And the court has just a minute. Under the circumstances, the court cannot exercise its discretion. So, in view of the above, the bail, the bail prayer, the prayer for release of the accused is allowed. Stop. The accused Ritava Gatum is directed, the accused Ritava Gatum is directed to be released on bail, on execution of a bail bond of rupees 1 lakh. 1 lakh.
My lord,
It's 1 lakh. only.
my lord,
Then it will be rejected already.
my lord,
It's the amount it's itself
my lord,
mentioned in the law.
trial court has imposed 30,000 to co-accused, my lord. 30,000 may be imposed, lordship.
No, no, on that.
Lordship, my humble
No,
prayer, my lord.
It's only default, 1 lakh. To the
My lord,
sec-
50 may be imposed, my lord. My lord.
It
Because
will
they
be
are poor
executed before which court?
before special court, session court, my lord.
Okay.
My lord, accused, they are poor people, my lord.
Hmm?
Accused
It's
is a
secure,
four
it's
lakh.
surety only, surety only.
My lord, 50,000.
It's surety only, surety
Yes, my lord, that is there.
of 1 to be executed before the special court. Special court only?
Yes.
Okay, special court.
UP.
Yeah. With once, to be executed, to one, with one surety of like amount to the satisfaction of the executing court, with further direction that the accused shall cooperate and appear before the trial, appear before the eye of the case as and when called for. Number 2, that he shall not commit the similar offense as he is released. He shall not commit the similar. Shall not commit an offense similar to the offense of which he is accused of next 3, that he shall not directly or indirectly make any inducement, threat, or promise to any person acquainted with the fact of the case, so as to dissuade him from disclosing such fact to the court or to any police officer. What with the above this bail application?
Lordship, my lord, humble prayer, my
Stands
lord.
disposed of.
My lord, bail bond may be imposed 50,000, my lord.
No, what is the amount? See,
My lord,
say 10 years with fine which may extend to 1 lakh rupees, 1 lakh rupees.
and my lord, that is the, my lord, accused is a poor by government.
The
Even
poor is-
they could be able to pay our legal.
He has a money, he has a money to deal with all those drugs. He could manage. He will manage. No compromise in the amount.
Deeply obliged, my lord.
Maybe
Yes.
my lord, before I start, my lord, very grateful, my lord, for the accommodation, my lord.
This is
My lord,
heavy.
here, my lord,
Yesterday, same matter, Lordship. Yesterday, one matter was disposed, Lordship, or not disposed, Lordship. It was, AB was there, Lordship, yesterday. The applicant, the 2 applicants were there. One applicant is, authority letter was not there. Yes,
Mr. Purkasta.
Lordship, Lordship.
Okay. Have you annexed the order?
yes, annexure 4, my lord. Annexure 4, my lord.
What, it will be a similar order then.
Similar order may be passed.
Hmm?
Similar order may be passed.
Page 29, my lord.
Annexure 4.
Yes.
Page?
Page 29, my lord. Yes, page 29, my lord.
29.
Yes.
Okay, right. It's all the same.
Let me appear, my lord. I'm one of the bona fide purchaser, one of the Tamba.
Okay, your name is the Babli Ali. What is your name?
Nivas,
Brother?
Nivas Thakur, my lord.
Hmm?
Nivas Thakur.
What?
I'm Nivas Thakur, my lord.
Nivas.
Yes, my lord.
Just a minute, huh? Nivas Thakur.
Yes.
He is also one of the purchaser.
Yes.
Of the
Of the, my lord, there are two numbers involved in the FIR.
Okay, then right, huh?
Yes.
Mr.
N.K. Mori, my lord. N.K. Mori, my lord. M.U.R.R.Y.
Could you write? Okay. Direct counsel for the accused. The accused is the petitioner.
Yes.
Accused petitioner. And Miss El Hagelane, ADPP for the state of Arunachal. Stop, huh? Para. Okay, name will be changed. Take straight away, huh? This is a pre-arrest bail application filed under section 438 CRPC stroke 528 of the Bharatiya Nagarik Suraksha Sanhita 2023, filed by the accused, by the accused petitioner, namely Nivas. What Thakur?
Nivas Thakur, alias Nivas Thakur.
Nivas Thakur. Nivas.
VAS.
Thakur, alias Nivas. Nivas. Without H, Thakur would be sent. Apprehending his arrest in connection with Chimpu PS case number 34/2024, registered 24 under section 406, 468, 471, 420 of the Indian Penal Code, corresponding to GR case, GR number 593, 2024. Stop. Back. The Direct Counsel for the petitioner submits that the FIR was lodged by one Sri Tadar Nigla against one Mustaq Rahman for non-payment of the installment for the cost of 2 dumpers sold to him, with a further allegation that, and sold to him, stuff. The further allegation in the said FIR is that the said Mustaq Rahman has sold and transferred the said 2 dumpers to one. You are Nivas Thakur?
Yes, my lord.
Okay. Dumpers to him. Stop, huh? The dumpers to the present petitioner. Right first Nivas Thakur, huh? Within bracket present petitioner. Stop. Basing on the said allegation, comma, the above PS case was registered against Sri Mustaq Rahman. Stop, huh? Para. The case of the petitioner is that he had purchased 1 dumper from the accused Mustaq Rahman with the belief that the accused Mustaq Rahman is the bona fide owner of the said dumper, as the accused had all the relevant documents with him. Stop. The accused was under the possession of all the relevant documents with him. Stop. Para. It's not para. Stop. Continue. However, the I of the case on 16/9/2024 had issued same on the same date.
Yes.
Okay, issued a notice to the petitioner under section 41 capital A bracket within bracket close of the CRPC, requiring him to appear
on 7/10/24, my lord.
Before appear in connection with the above PS case on 7/10/2024
Correct.
at Chimpu Police Station. At Chimpu Police Station. Stop. Hence, comma, the accused petitioner has a reasonable apprehension that the police might arrest him in connection with the above police station case and cause him an unnecessary harassment. Stop. Okay. Hence this petition, stop. Okay. Hence this pre-arrest bail application. Okay. Para, call for the case diary. Issue notice. Since Ms. L. Hage, Lanet, ADPP, additional PP has entered appearance and accepted notice on behalf of the state, no formal notice is required to be issued to the respondent. Stop. Para, in the interim, till the returnable date. Just a minute. Okay. In the interim. Now, before that, list this matter after.
The date was fixed, Lordship, on 28th, Lordship.
28 is, list this matter after 4 weeks, para. Then below, in the interim, till the returnable date, comma, it is provided Sri Nivas Thakur, alias Nivas Thakur, is being arrested in connection with the above Chimpu PS case number 34/2024 under section 406, 468, 471, 420 of the Indian Penal IPC, comma, he shall be released on interim anticipatory bail on execution of bail bond of rupees 30,000 with one surety of like amount to the satisfaction of the arresting authority, with a further condition that the accused shall cooperate with the IO of the case and shall appear before him.
So on 7, Lordship, he.
Agent when called for. Stop. Para. List it again on 28/10/2024, on which date the learned ADPP shall produce the case diary.
He may be directed, Lordship, within 1 week or 10 days to appear before the IO to give a statement, Lordship.
Any day we will go, my lord.
If you don't go, it will be your disadvantage. If you go, then it will be your advantage.
Yes, correct.
Because so sooner the better.
Yes.
You go, and then when you go there, go with one attendance application. Attendance application.
Yes, my lord.
I am appearing or surrendering or appearing. Even if surrender, it's always better to surrender. Then he will arrest and immediately release on the same day at the same time. That is always better. Otherwise, this may also cancel. So if you appear, once you are appear and arrested, then it will be your advantage.
Yes, correct.
Appear within a week.
Will appear, my lord.
Okay. And that's
we are obliged, my lord. Obliged.